I'm Chris Maru, bringing you the Texas Monitor Week in Review. Maybe if they'd done a few dollars a year since the last raise, no one would have noticed. But Elgin Mayor Chris Cannon bent over backwards to make sure the public knew it was coming and why. The City Council worked the numbers so the overall budget wouldn't increase, and they made sure what they did wouldn't go into effect until June 2019, after the next city election. But guess what? There wasn't any way around it. At a regularly scheduled meeting on December 4th, Cannon and current council members tripled the council's monthly pay and boosted the mayor's pay by nearly 3.5 times. Local headlines didn't spare the elected officials of this town of 9,700 east of Austin. Beginning next summer, though, council members who now make $50 a month will make $150 a month. Cannon, who served as mayor for $75 a month since 2016, will get a pay bump to $250. So they're not exactly breaking the bank. A legal spat between a Texas attorney and an Arizona man has prompted over 36 media groups to sign on to a brief with the Fifth Circuit Court of Appeals in New Orleans in a case that would determine if Texas Anti-SLAPP law can be used to fight alleged nuisance lawsuits that are filed in federal court. The nation's largest media corporations and organizations are among those that have filed in support of the defendant, Thomas Retzlaff, including the Associated Press, the Washington Post, the New York Times, and National Public Radio. Now, a SLAPP suit doesn't involve actually bringing your hand up against someone's face. It's shorthand for strategic lawsuit against public participation. It's an action to discourage the exercise of some First Amendment rights, including free speech. In 2011, the Texas legislature passed the Texas Citizens Participation Act to combat such lawsuits, which have often been used to stymie investigations by media entities and others seeking public records or reporting fully on news events. The suits are intended to intimidate the defendants with the potential high cost of legal fees. The media groups, in their amicus brief, meaning friend of the court, contend that that case has potentially broad ramifications for their organizations and others that depend on anti-SLAPP protections to avoid the sometimes debilitating cost of litigating meritless claims that infringe their First Amendment rights. For more government accountability news around the state, go to texasmonitor.org. You can also follow us on Facebook at Facebook.com/The Texas Monitor and on Twitter @The Texas Monitor. I'm Chris Maru.